Hey everyone, welcome to Yadhu Study Hub. My name is Sushma, and in today's class, we'll understand few important topics from the Law of Evidence Act 1872. Initially, with the introduction of judicial system in India, the need for the enactment of evidence became necessary. Even though English law was there, it was not suitable for India due to the personal laws, that is Hindu law and Muslim law prevailing in India back then. On recommendation of commissioners, the evidence bill was prepared and submitted to the Council of Governor General of India. The important points to be remembered for any exam of the MCQs. The first one is James F. Stephen prepared draft and presented before the council in 1872, and same got enforced in 1872, entitled the Indian Evidence Act 1872. The Indian Evidence Act consists of 116 sections with 11 chapters. The act was enacted on 15th March 1872 and same was enforced on 1st September 1872. These 2 points are very important. Usually they ask enactment and enforcement, or when the act came into force. So the act came into force on 1st September 1872. The Evidence Act is divided into three parts. Part 1, Preliminary Relevancy of Facts, Section 1 to 55. Part 2, On Proof, Section 56 to 100. Part 3, Production and Effect of Evidence, Section 101 to 16. Now, what is evidence in general? The word evidence is derived from Latin word evidentia, which means to show clearly. For example, if A has entered into a contract with B, the document to be shown, that is to show clearly that A has entered into a contract with B. Second is to discover clearly. In case of criminal cases, if there's a murder, then how the murder has happened, or what things were used to commit a crime, to discover clearly. So third one is to prove, that is based on these evidence to prove before the court of law. The next one is to ascertain, that is to be clear. Next one is the object of evidence. The object of evidence is to help the court to reach or to ascertain the truth and to avoid the confusion in the mind of the judges. Application of the Evidence Act. Evidence Act applies to whole of India. The next one is Evidence Act applies to all judicial proceedings and does not apply to the proceedings which are not judicial or non-judicial proceedings. So now what is judicial and non-judicial proceedings? Judicial proceeding means, for example, A has entered into a contract with B. There is a breach of contract and B has filed a suit against A. So here there is a dual relation, that is between one person and another, or it can be a group of person or community in general. Okay, this is called as judicial proceedings. Whereas in case of non-judicial proceedings, for example, departmental inquiry held for the police officers, or an inquiry by a collector under the Land Acquisition Act. Here you can see that an inquiry is made about the matter of facts, where there is no discretion to be exercised and no judgment to be formed. But something has to be done in certain event, that is duty. So it is said to be administrative in nature. Okay, so this is non-judicial proceedings. So Evidence Act applies to all judicial proceedings. Is that clear? The next one is the Evidence Act does not apply to Army Act, Indian Navy Discipline Act, Air Force Act, proceedings before arbitrator. So, why it is not applicable to arbitrator? Because an arbitrator is not bound by the strict rules of evidence, because the main object behind the arbitrational proceeding is to avoid the elaborate procedure of the regular trial. Okay, regular trial. And if arbitrator is not acting in accordance with the rules of evidence, he cannot be brought as the cause of action against the arbitral award. Okay, so an arbitrator is expected to follow the rules of natural justice only. Now another question that arises is Evidence Act is applicable to civil or only criminal cases? So the Evidence Act applies to both civil and criminal. In case of civil, section 52 and 55, that is the character of parties, and section 115 to 117, estoppel. Whereas in case of criminal, section 24 to 30, that is confessions, and section 53 to 54, character of an accused person, section 120, competency of spouse as witness for or against the other spouse, section 155, character of the prosecutrix in case of rape or attempt to ravish. The next one is evidence is lex fori, means law of land where court proceedings are taken. So it was held by the House of Lords. So the law of evidence is lex fori. That means which governs the courts whether a witness is competent or not, whether a certain evidence proves a fact or not, or it is to be determined by the law where the cause of action arises, where the remedy is enforced, and where the court sits to enforce it. So when the evidence is taken, so for example, if the cause of action is taken in one country for a suit or an action in another country, then the evidence law is applicable to the recordings of the evidence, and it would be the law prevailing in the country where the proceeding is going on. So you can say that lex fori means the law of the place of the action. Okay, the law of place of the action. So the law of evidence is lex fori, that is which governs the court, and this is purely the matter of convenience. Next, what is evidence and the classification or kinds of evidence we'll discuss in next class. If you liked my video, do like and subscribe to my channel. Do comment. So until then, thank you. Bye.